that one, there's also a lab there in case they don't.
Okay, because when we come in, I'm gonna probably introduce the judge and I'll put the hand up over here and I'll move it.
Yeah. Okay. I'm gonna head upstairs to the office.
Yeah,
Do you want a wireless handheld?
that's what I meant. That's what I meant.
I'm sorry.
guys are ready? You guys can have a seat. Welcome to the 2024 Battle of the Experts Championship Trial. At the end of our trial, our very large and esteemed panel here is going to introduce themselves, but for now, I just want to introduce our presiding judge. This is Judge Maria McLaughlin. She was a district attorney in Philadelphia. After that, she was a judge in the Philadelphia Court of Common Pleas, which is the trial division here in Philadelphia. And now she's a judge, for the last 7 years, a judge on the Pennsylvania Superior Court, which is the appellate court here in Pennsylvania. But Judge McLaughlin's real claim to fame is that 6 years ago, she swore me into the bar. So
It absolutely is.
We're really
that
happy
was the
to-
highlight of my career.
she said it, her words. So with that, Judge McLaughlin, whenever you're ready.
All right, so welcome. I am very excited to be here today. I am a local Philadelphian, although I represent the whole state of Pennsylvania. So bear with me because I've also been on the appellate bench for the past 7 years, so I'm used to being interactive. So it's been 7 years since I've been on the trial bench, so I have to put that hat on. But I am excited and welcome to Philadelphia if you are not from Philadelphia, and I look forward to hearing your arguments. So you may begin.
Appearances from the plaintiff, Your Honor. Good afternoon. My name is Kensington Cotter, representing the plaintiff Clark Doig. Today I'm joined by my co-counsel.
Good afternoon, Your Honor. My name is Michaelin Struble, also appearing on behalf of the plaintiff. After defense has made their appearances, we have just a few housekeeping matters.
Okay?
Good afternoon, Your Honor. My name is Grace Grossenbach, and alongside my co-counsel Jacob Powell, we will be representing the defense today, Klein Wrestling Alliance. Like the plaintiff, we are also ready to proceed pursuant to a few housekeeping matters and 3 motions in limine.
Okay.
Your Honor,
And who else is seated at the table?
This is our party representative, Mr. Cody Cotter.
Okay. Morning.
Your Honor, may we have permission to move freely about the well, including during opening, closing, and examinations?
Certainly, as long as everything's done professionally.
Thank you. Under Rule 603, may we constructively swear in all witnesses?
Yes.
Once an exhibit has been admitted into evidence, should we ask permission every time we publish to the jury or just the first time?
Every time, because there may be an objection or something of that nature, so individually.
Thank you. Speaking of exhibits, during meet and confer, we agreed to pre-admit several exhibits.
Okay?
May I list them for you?
Yes.
Exhibits 1, 3, 4, 5, 6A, 8A, 9, and 10.
Okay?
Additionally, may we have permission to use exhibits 1, 6A, and 8A in our opening statement?
Absolutely. Any objection?
No objection, Your Honor. The defense intends to do the same with Exhibits 6A and 8A.
Okay.
Thank you, Your Honor. Nothing further from the plaintiff for housekeeping.
Okay.
Your Honor, as for the defense, we would like to put the court on notice that today's proceeding is a bifurcated trial. And the issue of liability is all that will be at issue today, and therefore any mention of damages is not relevant. Additionally, since this is Battle of the Experts, we plan on bringing an expert in today's case, Mr. Sism. Would Your Honor like us to formally tender Mr. Sism as an expert at the time, or lay the foundation and then move on?
You can do whatever. It doesn't matter to me. If you want to lay the foundation, that's
Yes, Your
fine.
Honor. And finally, Your Honor, there is a joint exhibit list on page 2 of the record listing out the exhibits, I apologize, with their original identification numbers. We ask that they retain those original identification numbers for purposes of today's trial.
Okay, thank you.
With that, the defense is ready to proceed to motions.
Okay.
Your Honor, the plaintiff doesn't have any motions, but we anticipate the defense does have one.
Okay.
Yes, Your Honor. So, as they mentioned, we had a very successful meet and confer, and we were able to come to an agreement on a few of our motions, and I can start with those just for the record, if that's okay.
Okay.
So the first agreement that we came to is that we will exclude any mention, any testimony regarding a 2019 lawsuit that involved KWA and a separate wrestler. In addition, we also stipulated that any mention of a new policy that KWA implemented as a result of the accident that happened in this case at Klein Wrestling Alliance will also be excluded under Rule 407. And then finally, we came to an agreement that any testimony from any witness regarding what happened after Mr. Doig unexpectedly passed away during the stunt involving Mr. Cotter's decision for the show to go on would be excluded from evidence today. And I believe the plaintiff would agree that those have all been stipulated to.
Yes, Your Honor. And just a no on the 407 stipulation. We did agree not to talk about the policies that changed after Clark Doig died, with the caveat that if the door is opened, we would be allowed to use it as impeachment evidence.
Yes, Your Honor, that's right. The only motion that the defense has involves the plaintiff's expert, but by way of background on the case, this is a wrongful death lawsuit brought by the estate of Mr. Doig. They are suing Klein Wrestling Alliance for negligence after Mr. Doig unexpectedly passed away during a wrestling stunt. Now, we anticipate and expect the plaintiff to call an expert, Mr. Sukesh, to testify. Mr. Sukesh produced a report before trial and proffered several opinions in that report. We don't contest his qualifications insofar that they involve stunts or stunt safety. However, Mr. Sukesh did proffer and opine on a specific piece of evidence or specific issue that should be excluded under 702. The opinion in Mr. Sukesh's report, or Mrs. Sukesh, I apologize, is that, quote, just as KWA, Klein Wrestling Alliance, did in 2021, a wrestling company should hire a stunt coordinator. Now, Your Honor, the problem with this specific opinion is that it's a wrestling-specific opinion. And Mr. Sukesh or Mrs. Sukesh has no background training qualifications in the wrestling industry. She's never been hired as a wrestling stunt safety professional, and therefore, under Rule 702, that opinion on what a wrestling company should do or should have done should be excluded.
Thank you.
Response, Your Honor?
Yes.
This motion is premature. We've not yet had the opportunity to lay the foundation for Ms. Sukesh's expertise and experience and credentials. As an offer of proof, Ms. Sukesh will testify that she does have knowledge of wrestling industry standards. But again, right now, this is premature.
Okay. I agree. It
Yes,
is
Your Honor.
premature. Let's first see what her qualifications are.
Yes, Your Honor.
Okay.
Is it okay if I re-raise the objection when it becomes appropriate?
You should.
Yes, Your Honor. Thank you. At this time, the defense has no other motions or housekeeping matters, and we're ready to proceed to opening statements.
Okay.
Plaintiff is ready to.
You may proceed. Okay.
Easy to open, easy to die. It's a Saturday afternoon in August, inside the Klein Wrestling Arena. Tonight, we'll hear the roar of the crowd, see the enormous wrestlers entering the ring. We'll smell the hot dogs, the beer, the sweat. But for now, the seats are empty. The arena is quiet. There are only two people ringside: the company owner, Cody Cotter, and one of his wrestlers. The wrestler knows the plan. Tonight, he'll be entering the ring not from behind the curtain, from the ceiling, 78 feet high, supported by nothing more than a cable locked to the back of his vest. But he's practiced. He's ready. Until Mr. Cotter tells him he's making just one little change, replacing that lock on the back of his vest with a new device called the snap shackle. This is going to make the stunt look better, he tells him. Because when you get down to the mat, it'll be so much easier to open. Members of the jury, the evidence will show that was the problem. The snap shackle opened too easily. In fact, it was designed to open easily. The evidence will show that's why it wasn't approved for aerial stunts. It wasn't used by stunt companies or other wrestling companies. Today, you won't hear any evidence that any other wrestling company has ever trusted a man's life to this device. This is Clark Doig. He is the wrestler who the defendant gave that new equipment. He was 35 years old. He had 2 children. On August 6th, 2022, he had just begun his descent when the defendant's snap shackle popped open. The last moments of his life were in free fall before he landed on the mat and never got up Today, his family is suing the defendant for giving him the wrong equipment because at 78 feet off the ground, easy to open meant easy to die. As the plaintiff, we have a burden to prove that it was more likely than not that the defendant's negligence, their carelessness, caused Mr. Doig to die. We will be able to meet this burden by proving 3 key facts. The defendant had safe equipment. They replaced it with dangerous equipment. That decision killed Clark Doig. Starting with the first fact we will prove. The defendant had safe equipment. Sid Gaskins was the defendant's announcer. She'll testify that the defendant had done a similar stunt just the year before. They hired a stunt coordinator who gave them the equipment to use, including the locking carabiner. You will hear expert testimony that the locking carabiner is the industry standard for slow-moving descents like this one. It's used by stunt companies and other wrestling companies. That's because it doesn't open on accident. You have to grip the lock, twist it, and push it. The evidence will show that when the defendant used this device, no one got hurt. The second fact will prove the defendant replaced the safe equipment with dangerous equipment. It's 4 days before the big stunt, and rehearsals look great. Mr. Cotter watches Clark the Dragon Doig in his shiny gold dragon costume descending from the ceiling. He imagines the smoke, the lights, the music. The crowd is going to love it. But as Mr. Doig gets to the bottom of the mat, he fumbles as he unlocks the carabiner. Takes him too long. Doesn't look cool. So, Mr. Cotter decides to make a change. But you'll learn he doesn't call up his old stunt coordinator and ask what equipment to use. In his words, he doesn't want to spend the money. Instead, he Googles it. Finds the snap shackle. And good news, Amazon can get it here on time. By Saturday afternoon, he's added this green cord and taped it to Mr. Doig's vest so that he can open the snap shackle easily. Members of the jury, you don't have to hear that story from our witness. It's what Mr. Cotter will admit on the stand. You'll also hear from 2 experts, ours and the defendant's. But these experts will agree. The snap shackle is not the industry standard. It would open if this green cord moved even a quarter of an inch. It would open if Mr. Doig's shoulder moved even a quarter of an inch. Their own expert will tell you the defendant gave Mr. Doig a device that was more dangerous. The third fact will prove their decision killed Clark Doig. Members of the jury, it will be undisputed that during Mr. Doig's descent, none of the equipment approved by a stunt coordinator failed. Undisputed that it was their snap shackle that opened. Undisputed that when their snap shackle opened, Mr. Doig died. Now, after Mr. Doig died, the defendant said it was his fault. He was flapping his arms like a dragon when we told him not to. That's why the snap shackle opened. Members of the jury, remember that when they try to blame the victim, they have a burden. They will not be able to prove that Mr. Doig was flapping. They will not be able to prove that Mr. Doig was negligent. Members of the jury, the evidence will show when Cody Cotter handed Clark Doig that snap shackle, he knew it was the only thing between Mr. Doig and that 78-foot fall. He knew that in order for Mr. Doig to stay alive, the snap shackle had to stay closed. But you'll learn that he chose it because he liked how easily it opened. At the end of today's trial, we will ask you to find the defendant liable for Mr. Doig's death. Because at 78 feet off the ground, easy to open meant easy to die. Thank you.
May it please the court, opposing counsel, members of the jury. Clark Doig's job was dangerous. He was a professional wrestler who was known for doing high-flying aerial stunts. He was the Evel Knievel of wrestling. But in order for stunts like this to be safe, there has to be a plan, a safe plan. And once that plan is made, the plan then has to be precisely followed, carefully practiced, thoroughly performed. When all three of those things come together and everyone's on the same page, everyone's ready to follow the plan, KWA and Clark are going to put on a great show. A safe show. But as you've just heard, it's not what happened on August 6th. What happened on August 6th is a tragedy. Everyone here agrees with that. But the plan for the stunt that took Clark Doig's life was not precisely followed. It was not carefully performed. Members of the jury, you will learn that it was ultimately Clark Doig who ignored the plan. When you ignore the plan, you invite the risk. Now, Klein Wrestling Alliance is a professional wrestling company right here in Philadelphia. I want you to meet part of that wrestling family at KWA. This is Cody Cotter. Cody has been working in the professional wrestling industry since he was a teenager. He worked with his dad at his dad's company. When his dad passed in 2017, Cody knew that's what he wanted to do. So he opened KWA the following year. But just like every other business in the country, when COVID hit, it hit KWA too. It hit him hard. The business was struggling. But just like every wrestler that Cody employs, Cody's a fighter too. And he was determined to make sure that KWA would get back on its feet again. So what does he do? Well, he calls back one of the best wrestlers that he knew from KWA, Clark Doig. But at the time, Clark was struggling too. You see, despite being one of the best technical wrestlers KWA had, Clark just couldn't get the fans to attach to him. He didn't have a gimmick, which is a character for the wrestling world, a persona that the wrestlers put on to get the fans to want to cheer for them. He didn't have one of those. And he struggled to talk to the crowd with his mic skills. Something needed to change. Something did change. Clark became the Dragon, a clumsy but lovable character, and he'd dress up in a dragon costume. And from the moment that Clark debuted as the Dragon, his popularity took care of itself. Fans had someone to cheer for, someone to root for. His mic skills got better. But the next performance that the Dragon had on the schedule was August 6th, the Brotherly Slam. For KWA, this is a premium event, the big show. There's higher stakes, a championship on the line. Clark knew he needed to go big. What better way to go big than a high-flying aerial stunt? As I mentioned earlier, Clark was no stranger to dangerous, difficult stunts. You see, at his time with KWA, Clark had jumped off of 16-foot ladders, 12-foot steel cages. He was thrown through a glass window one time. As crazy as that sounds, that is professional wrestling. That's what professional wrestlers do. That is their job. And we remember that these people are trained professionals. And even amongst those trained professionals, Clark set himself apart. He was the best at performing aerial stunts. So, considering Clark's reputation for safety when he was performing stunts, his technical ability, his extreme precision, KWA and Clark made a plan. And that plan was for him to debut a new stunt at the Brotherly Slam show. Now, the plan for this stunt would start with Clark up on top of the catwalk at KWA. And from the catwalk, he'd be in a harness and a vest. Attached to that vest would be steel cables using two pieces of equipment to link his vest to the rappelling rope. There'd be a locking carabiner on top, with a snap shackle on the bottom, interlocked together and attached to the back of Clark's vest, connecting him to the ceiling. You will hear that as Clark was being lowered, he would keep his arms stretched out just like this, still, like he was flying, like a dragon. And when he was 5 feet from above the bottom of the ring mat, he would release himself and begin the event. You'll hear from Cal Sism today, an expert in wrestling stunt safety. And Mr. Sism will tell you that this equipment, this design, this plan for the stunt, it was safe. It was safe enough and strong enough for the stunt that Clark was going to be performing. If Clark followed the plan. Today, you'll also hear that that plan was working. You see, KWA started practicing this stunt with Clark. They practiced it over and over and over again, with Cody there every time, checking on Clark, making sure he was okay with the stunt. You'll learn that the only problem with the stunt was Clark. And he began to flap his arms, coming down. Cody sees this because he's at practice. He immediately goes down to him. He says, don't do that flapping thing with your arms. It's not safe. If you're not still, you might pull that green cord. This is a matter of life and death. You'll hear that those next two practices, Clark did follow the plan. After Clark heard from Cody to not flap his arms at practice, those next two practices, he kept his arms still. But something changed the night of August 6th. As Cody and Clark are on the catwalk, Clark's about to make his debut entrance into the brotherly slam with this new stunt. Cody begins to lower Clark down with the ropes, just as they had done 8 times before. And Cody watches as Clark is just below the catwalk. He begins to move his arms, like he's going to do that flapping thing with his arms again. And Cody's stuck on the catwalk, watching helplessly. Only 1 or 2 quick movements, and suddenly Clark is released from the harness. He falls to the ring mat below. The plaintiff has brought a case for negligence today, and in doing so, they have a burden. That burden is to prove to you by a greater weight of the evidence that KWA was not reasonable in the stunt that they planned for Clark Doyd, that they acted not reasonable. They will fail to meet that burden today because you'll learn KWA was reasonable. KWA was reasonable in planning this stunt, the equipment that they chose. They were reasonable in practicing this stunt with Clark over and over and over again, instructing Clark the proper way to perform the stunt. It was Clark who ignored the plan. When he did that, he invited the risk that something would go wrong. On that last note, we have a burden in today's case as well. We've raised the affirmative defense of assumption of the risk. We have that same burden to prove to you by a greater weight of the evidence that not only did Clark appreciate the risks of the stunt on August 6th, but he voluntarily participated in them. And it was that risk that cost Clark his life. If you ignore the plan, you invite the risk. When Clark made the decision to not follow the plan that KWA set out for him, he invited the risk that the stunt would not go the way it was supposed to. That is why we are here today. Not the negligence of KWA. At the end of today's trial, my co-counsel Jacob Powell will ask that you find KWA not liable.
Okay. Do you want to call your first witness? Okay.
Plaintiff calls Sid Gaskins.
Assume she's been sworn.
May I
Maybe.
proceed?
Yes, you may.
Good afternoon.
Good afternoon.
Please introduce yourself to the jury.
Hi, my name is Sid Gaskins.
Are you familiar with the defendant in this case, Klein Wrestling Alliance?
Yes,
How?
I used to work for them.
Were you familiar with the victim in this case, Clark Doig?
Yes.
How?
He was a wrestler for KWA, and we were good friends.
I want the jury to meet him. Your Honor, I'm holding what's been pre-admitted into evidence as Exhibit 1. Permission to publish to the jury.
You're permitted.
Ms. Gaskins, who are we looking at?
That's Clark.
What day did he die?
August 6, 2022.
Were you there when he died?
I was.
How did he die?
He fell while he was doing a stunt.
Had the defendant, Klein Wrestling Alliance, ever done a similar stunt like that in the past?
They did.
When?
In 2021.
Did anyone get hurt?
No.
From what you saw, between the stunt in 2021, where no one got hurt, and the stunt in 2022, where Clark Doig died, was there anything different?
There was.
What?
They used different equipment.
Let's start at the beginning. When did you begin working for the defendant?
I started working at KWA in 2021.
What kind of work did you do?
I was the booker and the announcer.
And just to be upfront with the jury, why did you stop working for the defendant?
I was actually fired.
Now, you told us that while you were working for the defendant in 2021, they did a similar stunt and no one got hurt. Who provided the equipment for that stunt?
We had a professional stunt coordinator.
I want the jury to see that equipment. Your Honor, I'm holding what have been admitted into evidence, pre-admitted into evidence as Exhibits 3 and 5. Permission to publish to the jury?
You may.
Permission to approach the witness.
Certainly.
Ms. Gaskins, what is Exhibit 3?
That's the ring.
What is Exhibit 5?
The catwalk.
Not 2021 stunt where no one got hurt. How did the performer get from the catwalk to the ring?
He was lowered by a rope.
How many feet was the fall from the catwalk to the ring?
It was 78 feet.
Your Honor, I'm holding what have been pre-admitted into evidence as Exhibits 9 and 10. Permission to publish to the jury
Permitted?
and permission to approach the witness.
Certainly.
Ms. Gaskins, what is Exhibit 9?
That's a vest.
What is Exhibit 10?
It's the rope.
Is this the same equipment that was used in that 2021 stunt where no one got hurt?
Yes.
During that stunt, how was the vest connected to the rope?
It was connected by locking carabiners.
How many locking carabiners?
2.
Your Honor, I'm holding what's been pre-admitted into evidence as Exhibit 8A. Permission to publish to the jury.
Yes.
Ms. Gaskins, do you recognize this?
Yes.
What is it?
It's one of the locking carabiners.
Is it one of the locking carabiners that was used in that 2021 stunt?
Yes.
You told us that after the defendant did that stunt in 2021 where no one got hurt, they changed some equipment. What piece of equipment did they change?
Instead of using that locking carabiner, they started using a snap shackle.
I want the jury to see that snap shackle. Your Honor, I'm holding what's been pre-admitted into evidence as Exhibit 6A. Permission to publish to the jury.
You're permitted.
Ms. Gaskins, do you recognize this?
Yes.
What is it?
It's the snap shackle that they used in 2022.
According to Cody Cotter, who decided to replace one locking carabiner with the snap shackle?
Well, Cody Cotter did.
Did Mr. Cotter say why he made that change?
He said that using the snap shackle, it would be easier to unlock.
According to Cody Cotter, did a stunt coordinator approve the switch from the locking carabiner to the snap shackle?
No.
Did Mr. Cotter say why he didn't hire a stunt coordinator?
He said that he didn't want to spend the money.
How many days did the defendant give Mr. Doig to practice with the snap shackle?
0. They made the change the same day.
When you say the same day, is that the same day that he performed the stunt?
Yes.
Let's talk about how Mr. Doig died. Where were you when Mr. Doig attempted the fatal stunt?
I was sitting ringside.
Tell the jury what you saw.
He just started falling. He was attempting to do the stunt, but he just fell and hit the mat.
I want to be clear for the jury. Between the 2021 stunt, where no one got hurt, and the 2022 stunt, where Mr. Doig died, how many pieces of equipment did the defendant change?
1. The snap shackle.
Thank you. No further questions.
Okay.
Miss Gaskins, you worked for KWA
Yes,
for about 2 years, you said.
I did.
But just so everyone's on the same page, you were fired in 2023.
That's right. Cody Cotter fired me.
And you're here today to testify against KWA.
Yes.
Now that we've talked about that, I want to talk about professional wrestling. Professional wrestling, part of it is about performing stunts.
Exactly, yes.
And those stunts can be dangerous.
Certainly.
But there are no stunt doubles in professional wrestling.
No, all the wrestlers perform the stunts themselves.
That's right. The wrestlers are expected to do their own stunts.
Yes.
But according to you, Clark was one of the best at performing stunts,
He was.
especially high-risk aerial stunts.
Yes.
Those kinds of stunts, they require extreme precision.
Right.
But Clark could do them.
Yes, I'd say so.
You'd seen him jump off of 12-foot ladders.
Yes.
You saw him jump off of 16-foot steel cages.
That's correct.
You saw him get thrown through a glass window one time.
Yes.
But all of that stunt capability did not make Clark the most popular wrestler at KWA.
No, he definitely was not.
Because according to you, he didn't have a gimmick.
Right.
We know that a gimmick is a character.
Yes.
Without having that, a wrestler like Clark would struggle with popularity.
Exactly.
So he needed to make a change.
Yes.
Clark agreed to make a change.
He did.
He became the Dragon.
That's right.
And the Dragon would allow Clark to showcase some of his best skills.
Yes.
Because dragons are supposed to fly.
I guess so, yes.
So he would perform high-risk aerial stunts as the Dragon.
That's what he was supposed to do.
And the stunt planned for August 6th was a high-risk aerial stunt.
Yes.
KWA practices their stunts before they perform them, correct?
They do.
I want to talk to you about a few of those practices.
Okay.
Practices for this stunt started the Tuesday before the Brotherly Slam.
That's right.
You were at those practices that day,
I was.
all 4 of them.
Yes.
You watched as Clark struggled with this locking carabiner.
He struggled to unlock himself for like 10 seconds.
That's correct. He struggled to twist that lock and release himself.
Yes.
That was taking some time.
Yeah, like I said, 10 seconds.
Right, but that kind of time was not practical for this stunt.
I guess it didn't look as clean, so sure.
Well, you heard Clark tell you that he felt lame, just dangling there, trying to unlock the carabiner.
He did say that.
And you know that a lame stunt is not going to connect with an audience.
I don't think it would.
So Cody comes in on August 6th, bringing a snap shackle.
That's right.
He sets it down where you're sitting.
Yes.
You begin to run practices with that snap shackle.
Yes, they did.
Specifically, Clark practiced 4 times with the snap shackle.
Yes.
At no point did you ever hear Clark say, I don't want to use a snap shackle.
No, he never said that.
What he did tell you was that the snap shackle was so much easier to open.
Yes, he did.
The problem with the snap shackle that day was Clark flapping his arms.
He flapped his arms one time during practices, and then he didn't do it again.
Right. You saw him flapping that one time, and then you saw Cody address it with Clark.
That's right.
You saw Cody go down to Clark
Yes.
and tell him, do not move your arms like that.
Yes.
You heard him tell Clark, it's not safe.
I did.
And as you just said, there were 2 more practices after that,
Right.
and you were there.
I was.
You saw Clark as he kept his arms still,
Yes.
just like the stunt was planned.
Yes.
Now, you spoke to Clark right before he made his entrance at the Brotherly Slam.
I did.
You saw him right before he went out in his mask,
Right.
in his cape,
I did.
in his vest.
Yes.
You asked Clark if he was still sure he wanted to do the stunt.
I did.
And in response, he didn't say, I'm worried about this.
No, he didn't say that.
He didn't say, I'm uncomfortable with the stunt.
No.
He didn't tell you he didn't want to use a snap shackle.
No, he never said anything like that.
What he did tell you was it's time for the dragon to fly.
Yes.
No further questions, Your Honor.
Thank you.
Nothing further from this witness.
Okay.
Plaintiff calls River Sukesh to the stand. May I proceed?
Yes.
Good afternoon.
Good afternoon.
Can you introduce yourself to the jury?
Hi, I'm River Sukesh.
What do you do?
I'm the Chief Stunt Safety Officer at Walt Disney Studios.
What do you do as Disney's Chief Stunt Safety Officer?
Think of all the stunts you see in Disney movies. The falls in the Avengers, the fights in Black Panther, jumps in Pirates of the Caribbean. I oversee stunts like those ones to make sure the performers are safe when they're doing them.
Ms. Sukesh, how are you involved in this case?
I was asked to determine why Clark Doig fell when he was performing an aerial stunt.
Before we talk about your conclusions, I want the jury to hear your qualifications.
Okay.
What degrees do you have?
I have a mechanical engineering degree from Fordham University.
How many years of experience do you have with stunts?
23 years.
What positions have you held?
I've been a safety specialist, a stunt coordinator, and now, like I said, Chief Stunt Safety Officer.
Do you have experience performing stunts?
Yes,
Designing stunts?
I do.
Selecting equipment for stunts?
Of course.
Within the field of stunt safety, do you have any specialties?
Yes, I'm certified in wire rigging and work at heights.
What does that mean?
That means that when you're moving performers at great heights, it's important to be certified in the locks and ropes that move them, which I am. For example, I've done 25 stunts that started at above 40 feet high.
Let's talk about how you formed your conclusions. What information did you rely on?
I read eyewitness statements. I read the report of the defense expert, Sism. I tested the equipment that was used to perform this stunt, and I reviewed wrestling industry standards and stunt industry standards.
What methods did you use?
I tested the strength and the sensitivity of the equipment that the defendant used in this stunt, and I compared that equipment to those wrestling industry standards like I mentioned.
Were you able to form a conclusion about why Clark Doig fell?
I was.
Were you able to form that conclusion to a reasonable degree of professional certainty?
Yes.
Your Honor, we tender River Sukesh as an expert in stunt safety.
Your Honor, at this time, we raise our pretrial motion or objection, not again to the qualifications of Mrs. Sukesh in stunt safety, but if the opinion about what KWA and wrestling companies should have done with this stunt is elicited, it would be improper under 702 because, as they have just demonstrated, she has no industry experience with professional wrestlers.
Well, thus far, that hasn't been asked.
Yes, Your Honor. I anticipate that it will be based on what they have just discussed, but I can wait again to re-raise that.
Let's see where the questions go, but she indicates that her title is an expert in stunt safety. So your argument is because specifically she's not an expert in wrestling stunt safety?
Yes, Your Honor. Under 702, it requires an expert who wants to give an opinion or who is tendered as an expert to have the necessary background qualifications and experience in that field. Now, sure.
Well, in that field. So tell me why in that field means that it has to be wrestling. Can in that field mean that it's stunt safety, that it's with rigging, wire rigging and heights?
Yes, Your Honor, I'll explain. So, again, we will agree and concede that, sure, stunt safety, it's a big umbrella. However, this is the wrestling industry. This happened in a wrestling arena with professional wrestlers, and it's a professional wrestling stunt. And while it's a big umbrella, under 702, to have Ms. Sukesh opine about what happened in this wrestling arena with this professional wrestler would be a bridge too far, because it is a different industry. And 702 requires the expert to have expertise and knowledge in that industry.
Thank you.
Your Honor, has Ms. Sukesh been tendered as an expert?
Well, where are your questions going to go from here specifically?
I'm about to ask her conclusion, Your Honor.
Okay, and so I am going to accept her as an expert.
Yes, Your
So
Honor.
the objection's overruled.
Yes, Your Honor. Thank you.
Ms. Sukesh, tell the jury, why did Clark Doig fall?
I concluded Mr. Doig fell because the defendant, Klein Wrestling Alliance, gave him the wrong equipment for this type of stunt.
Let's break that down. When you say the defendant gave Clark Doig the wrong equipment for this type of stunt, what exactly was the stunt?
It's called a slow-moving aerial descent. Mr. Doig would start on a catwalk above the wrestling ring, 78 feet up high. From there, he'd be lowered on a rope. He'd be wearing a vest, and using a clip, that rope would be attached. Now, when he got 5 feet above the mat, he'd pull on that rope, which would open the clip, and he'd fall down onto the mat.
You mentioned a clip. What type of clip are we looking for if we want to attach it to a performer's vest?
For a stunt like this, you want something sturdy that doesn't open accidentally.
Why?
Because you have a performer 78 feet up. If that clip opens before it's supposed to, that performer could fall and be seriously injured.
You told us that you looked at industry standards. What type of clip was the industry standard for a stunt like this?
Something called a locking carabiner.
I'm holding Exhibit 8A, Miss Sukesh. What is it?
That's a locking carabiner. That is the industry standard for a slow-moving descent like this one.
And from what you reviewed, is this the industry standard for the stunt industry generally, or the wrestling industry specifically?
Both.
Before the defendant did this stunt in 2022, had they done it before?
Yes, they've done an almost identical stunt in 2021.
In 2021, who chose the equipment for the stunt?
For that stunt, the defendant hired a professional stunt coordinator.
What equipment did that professional stunt coordinator choose?
For the clips that we've been talking about, she chose a locking carabiner.
When the defendant did this stunt with a professional stunt coordinator using the industry standard equipment, how many people got hurt?
None.
Let's turn to the next part of your conclusion, that the defendant chose the wrong equipment. What type of clip did the defendant end up using with Mr. Doig?
They used something called a snap shackle.
Was that snap shackle approved of by a stunt coordinator?
No.
Who made the decision to switch from the locking carabiner to the snap?
Cody Cotter, the defendant's owner.
From what you reviewed, how much experience did Mr. Cotter have in selecting stunt equipment?
None.
According to Mr. Cotter, why didn't he hire a stunt coordinator?
He didn't want to spend the money.
You said that you tested the snap shackle. If I had you step down in front of the jury and gave you the equipment, would that help you explain your conclusions?
Of course.
May Ms. Sukesh step down?
Certainly.
Let's start with the industry standard. Can you show the jury how to open the locking carabiner?
Sure. For this, you can't just push on it to open it. You have to grab it, twist it, and press inwards.
Can you now show us all the steps it takes to open the snap shackle?
Sure. For the snap shackle, you just pull the green cord.
Ms. Struble, would you join us in the well? Now, you told us the defendant did this stunt in 2021. Using the locking carabiner, can you show us how they set up that stunt?
Sure. We can use this backpack to represent the vest that the performer wore. For the 2021 stunt, the KWA directly connected a locking carabiner to the performer's vest. This locking carabiner was connected to a second carabiner, which was connected to steel cables.
Why was that the right equipment to use for this stunt?
Because the locking carabiner doesn't open accidentally. Watch what happens when I jostle the bag. Nothing.
Can you now show us how they set up Mr. Doig's stunt?
Sure. Instead of locking a carabiner directly to the performer's vest, they use something called a snap shackle, like I mentioned. Now, as you can see, the snap shackle was connected to the locking carabiner here. And the snap shackle had this green rope attached to it, which was taped to Mr. Doig's shoulder. At the end of his descent, he would pull on the green cord, which would open the shackle and allow him to fall down onto the mat.
Well, what's wrong with that?
Because if Mr. Doig moved his shoulder too much, it could tug on this cord and open the shackle.
But if the defendant was still using the locking carabiner, does that make up for the problems with the snap shackle?
No. Because a chain is only as strong as its weakest link. If this snap shackle opened before it was supposed to, Mr. Doig would fall.
According to your testing, how much would that green cord need to move for the snap shackle to open?
Only 1/4 of an inch.
Thank you. You can retake your seat. Let's turn to the last part of your conclusion. How do you know that Clark Doig fell because the defendant chose a snap shackle?
Remember that chain I just mentioned? I looked for where the break was in the chain.
What do you mean?
Well, every other piece of equipment used for this stunt was still connected, other than the snap shackle.
Could his vest have ripped?
It didn't. I checked. Mr. Doig fell because the snap shackle opened.
Thank you, Ms. Sukesh. Nothing further.
May I proceed, Your Honor?
Yes.
Ms. Sukesh, good afternoon.
Good afternoon.
You have never given an opinion on wrestling stunt safety in court before.
Right.
Not in federal court?
No, sir. Not in any court. This is my first time.
Right. Not in state court either.
That's right.
Not even in traffic court.
No, sir.
Right. So this would be the first jury to ever hear your opinion
Yes, sir.
on any subject.
That's right.
Now, you've never worked for a professional wrestling association.
No, sir.
You've never worked for an amateur wrestling association.
No, I haven't.
You're not a professional wrestler.
No, sir.
You work at Disney World, right?
I work for Walt Disney Studios, and I oversee stunts there.
Right. And before that, it was Carnival Cruise Line.
Not directly before, but I have worked at Carnival Cruises.
And last I checked, there's no professional wrestling happening on the cruise ship, right?
No, sir, but I oversaw the stunts that they performed on the ships.
But they weren't professional wrestling stunts, right, Ms. Sukesh?
That's correct.
So, despite never having worked in professional wrestling, and despite never having coordinated a professional wrestling stunt, you're here today to give your opinion about this professional wrestling stunt. Is that right?
That's right.
Now that we understand that, let's talk a little bit about your opinions.
Okay.
Now, before trial, you produced an expert report, right?
That's right.
And in that report, you detailed 6 opinions,
Yes.
but you were not asked about all of those opinions on direct examination, right?
That's right.
Right. So the jury didn't get to hear all of your opinions that you prepared for trial.
That's right.
Okay, well, we're going to talk about those. But first, as a stunt safety specialist, you would at least agree with me that in order for stunts to be safe, you have to plan them,
Yes.
practice them,
That's right.
and then the performer must perform the stunt exactly how it was practiced.
Yes, depending on the stunt, that's obviously going to be more true in some situations than others. But yes,
Right, because some stunts are more dangerous than others.
right?
But you know that in this case, Mr. Clark or Mr. Doig did practice the stunt.
Yes.
And you would agree with me that in order to perform the stunt exactly how it was practiced, it requires precision,
Yes, you could say so.
experience,
Right, depending on the stunt.
and Mr. Doig had the experience.
Yes.
Because your opinion is not that Mr. Doig lacked experience in professional wrestling stunts.
No, sir. From what I read, he had lots of experience in professional wrestling.
Right, he had lots of experience in professional wrestling. So he did the stunt on August 6th.
That's right, he performed it that day.
Right, and he performed it with the equipment that KWA provided.
That's exactly right.
And at no point did Mr. Doig say he could not do the stunt.
No, not from any of the materials I read.
Right. Now, you spent a lot of time on direct examination being asked about a stunt in 2021, right?
That's right.
And this is a stunt that happened in 2022.
Yes, the stunt for which I provided an opinion happened in 2022.
Right. So these were two different stunts, just to be clear.
That's correct?
The stunt in 2021 did not require the performer to release himself during the stunt.
No.
The stunt in 2022 did involve Mr. Doig releasing himself during the stunt.
That's right.
And you would agree with me that different stunts call for different equipment, right?
Yes, depending on what the differences are.
Right, but different stunts can call for different equipment, Ms. Sukesh, right?
They certainly can.
Now, you also say, just like you did on direct, that a stunt coordinator should have been used.
Yes, that is my opinion.
And a stunt coordinator was used in 2021,
Right.
but it was not used in 2022.
No, unfortunately.
Because as you put in your report, but you didn't really talk about on direct, a stunt coordinator would be there to run the stunt.
Right.
They would be there to handle the equipment.
Absolutely.
They would be up on the catwalk, just like Cody Cotter was running the ropes.
That is right.
That's why you think a stunt coordinator should have been involved to do those things.
To do those things, among other.
Right, but what you did not tell this jury is that you also think that Cody Cotter did nothing wrong when operating the ropes, right?
No. From what I read, Miss Cotter made no mistakes while he was lowering Mr. Doig. My opinion is simply that I don't think he should have been the one lowering him.
Right, I get that's your opinion, but I'm asking about what Mr. Cotter did when operating the ropes. Your opinion also is that he did nothing wrong with running the ropes at night.
That's absolutely correct.
Mr. Cotter did not drop Mr. Doig when running the ropes.
No.
Now, your main opinion, as you just touched on, is that the snap shackle in this case was unsafe
Right.
because it could open accidentally.
Yes.
Right, and we didn't talk about this, or I didn't hear you talk about this on direct, but you put in your report that that reason is because the snap shackle's used for sailboats.
The snap shackle is used for sailboats. That's correct.
And that's part of your opinion that you think it's unsafe because it's not designed for stunts.
Yes.
Right. But as you would also say, there is no universal set of equipment for a stunt like this one.
That's right.
You didn't mention that on direct, right?
I don't recall saying that precisely, no.
Well, you didn't say it at all, Ms. Sukesh, right?
I'll take your word for it.
We'll let the jury take your word for it, okay?
Okay.
Because also in your report is that the equipment used in a stunt can be repurposed.
That's right.
Right. But the snap shackle was used in this case, and you said you tested it.
I did.
And you made sure that how much weight it could hold, right?
Yes, I found it could hold 975 pounds without opening.
Right, without opening. And Mr. Doig, we know, is about 177 pounds.
That's right.
So as far as safety goes, Mrs. Sukesh, there was no issue with the strength of the snap shackle.
There was no issue with how much weight it could hold.
Right, so it was strong enough to hold Mr. Doig.
That's right.
Right, and you know that they practiced the stunt several times.
Yes, 4 times.
They practiced it 8 times total.
Well, no, sir. They'd practiced the stunt using the snap shackle only 4 times.
Right, that wasn't my question. Maybe it was a bad question. They practiced the stunt, the rappelling from the ceiling, a total of 8 times.
That's correct, using 2 different sets of equipment First, they used the locking carabiner for 4 times, then 4 times using the snap shackle.
Right. So the 4 times with the locking carabiner, Mr. Doig never failed.
That's correct.
The 4 times with the snap shackle, Mr. Doig never failed.
That's right.
And at no point during those 4 times did the snap shackle ever prematurely release.
No, not from the materials I reviewed.
And in none of those 4 practices did it ever accidentally release.
No.
Right. Now, another one of your opinions that was left out on direct examination, but that's in your report, is that you think your expert opinion, Ms. Sukesh, is that KWA did not clearly instruct Mr. Doig on how to use the snap shackle. Isn't that correct?
That's right.
You believe that KWA and Cody Cotter should have better warned Mr. Doig.
Absolutely.
Right, and we've talked about the practices, and we've talked about Mr. Cotter being at the practices. He was at the catwalk, on the catwalk every time,
That's right.
running the ropes,
Right.
and at the end of every practice, he would go down and he would check on Mr. Doig.
Yes.
And during one of those practices, Clark was seen flapping his arms.
That's correct, by 2 eyewitnesses present.
Right, by Sid Gaskins
Right.
and by Cody Cotter.
That's correct.
They both saw Clark doing the flapping motion during the practices.
Yes, during the second practice run.
And that's when Cody left the catwalk to go check on Clark, and he said, "Do not move your arms like this.
That's right.
Do not do the flapping motion with your arms.
That's correct.
It's not safe."
Right.
Right. It's a matter of life and death.
I couldn't confirm that.
You read that in the deposition, right, Ms. Sukesh?
I read that in one of 2 eyewitness depositions. The second didn't mention that that statement was made at all.
Right. But you read it in the deposition, right, Ms. Sukesh?
I read it in 1 deposition. That's correct.
Thank you. Now, you did a demonstration with plaintiff's counsel here, in which they tested the strength of the snap shackle, or they demonstrated the strength of the snap shackle. And their demonstration showed that the locking carabiner did not open, right? This is not open right now.
No.
I'm moving it about the well of the courtroom. It's still not opening, right?
That's right.
Right. The only time it can open is when this pin opens, right here.
That's correct.
And the only time that pin can open is when you apply 9 pounds of pressure.
That's right.
And it releases.
Yes, sir.
Only with 9 pounds of pressure.
With 9 or more. It takes 9 pounds to pull.
And Ms. Sukesh, you reviewed everything today. You reviewed the equipment. And you didn't say this on direct. It's one of the last opinions you didn't mention. But your expert opinion is that no one knows exactly how that green cord opened.
That's right.
No one knows exactly what caused that snap shackle to open.
Right. We don't know in particular what caused the tension on the cord.
Right, Ms. Sukesh. No further questions.
Redirect, Your Honor.
Certainly.
Ms. Sukesh, on cross-examination, you told us that only one eyewitness told Clark Doig that it was a matter of life and death. Who was that one eyewitness?
Cody Cotter, the defendant's owner.
Thank you. Nothing further. May Ms. Sukesh step down?
Certainly.
And Your Honor, before the plaintiff rests, may we read a stipulation onto the record?
Certainly.
This is stipulation number 5. Clark Doig's cause of death was blunt chest trauma, specifically a transected aorta and internal bleeding upon striking the rings mat during the fall on August 6, 2022. With that, the plaintiff rests.
Thank you.
Yes, Your Honor. Since the plaintiff has now rested its case, the defense has a mid-trial motion it needs to raise.
Okay.
May I make that now?
Certainly.
Your Honor, at this time, the defense moves pursuant to Federal Rules of Civil Procedure 50 for a judgment as a matter of law. Because even in viewing the evidence in a light most favorable of the non-moving party, no reasonable jury can conclude that KWA was negligent or that the negligence caused Mr. Doig's death. For those reasons, and based on the evidence that we've seen today, the fact that Sid Gaskins could not see from the catwalk, there's been no testimony as to what happened between the catwalk and where the actual release of the snap shackle happened, and Mr. Sukesh was not an expert in professional wrestling. And based on that, we move and ask this court to grant the motion.
Thank you.
Your Honor, this motion should be denied because viewing the evidence in the light most favorable to the non-moving party, the plaintiff, a reasonable juror could find that we met our burden. The jury instructions said that we needed to prove 3 elements. First, that the defendant was negligent. Our expert testified that the use of the snap shackle violated industry standards. Second, that Mr. Doig suffered harm. He died. Third, that the defendant's negligence caused Mr. Doig's harm. Eyewitness and expert testimony confirmed that after the defendant used a snap shackle that violated industry standards, Mr. Doig fell and died. This question should go to the jury because a reasonable juror could find that we met our burden.
Thank you. And the motion is denied.
Yes, Your Honor. At this time, may we take a brief break and also have a time check?
Absolutely. How many minutes?
Our bailiff is.
Yes, the plaintiff has 32 minutes and 10 seconds. The defense has 30 minutes and 48 seconds.
Thank you.
And how long is the break allowed for? Okay. Yep. Okay, we will take a break, a quick recess for 5 minutes.
Thank you so much.
Okay?
Yeah, she has really done her speech yet, so maybe to really see her.
Okay, court's now in session. Defense, you want to call your first witness?
Yes, Your Honor. Defense calls Cody Cotter to the stand. Please introduce yourself to us.
Of course. Good afternoon. My name's Cody Cotter.
And what do you do for a living, Mr. Cotter?
I own a small independent wrestling company. It's called Klein Wrestling Alliance.
And how did you get involved in professional wrestling?
I started working at my dad's company when I was in high school.
Now, I want to move on from that. We know that Clark wrestled for you at KWA, but when did he start wrestling for you?
We first hired Clark back in 2019, but after the pandemic shut us down, we rehired him in 2021.
When Clark was hired, did he sign an employment agreement at KWA?
He did.
Citing court and opposing counsel to what has been pre-admitted as Exhibit 4. Permission to approach the witness and additional permission for my co-counsel to publish to the jury.
Certainly.
Mr. Cotter, I've just handed you Exhibit 4. Can you read the assumption of the risk clause on that employment agreement?
Sure. It says, by agreeing to render services to Klein Wrestling Alliance, Clark Doig understands and accepts the risk associated with employment of the services.
Now, you mentioned services. What do you mean by that?
We outline a few in the agreement, basically participating in wrestling matches, the live events, press conferences, things similar like the stunts.
Now, I want to talk more about Clark as a wrestler. What kind of wrestler was he?
He was extremely talented. Didn't get much of a reaction out of fans, though. He didn't have a gimmick, as we say, a character.
Now, you mentioned his talent. What kind of talent or experience did Clark have?
Clark had about 10 years of stunt experience. He's jumped off steel cages, ladders, things that you see on TV.
And earlier you mentioned that he didn't have a gimmick, and that made him a little less popular. What did KWA do to help him become more popular?
Well, we pitched a couple of ideas to him over the years, but eventually he came to us with this idea called the Dragon.
Explain the dragon character to us.
To put it bluntly, he was just going to become the lovable idiot. He would wear a big dragon costume, get really clumsy before he got into the ring, and then win his matches. It was supposed to be a fun character.
I want to talk specifically about the stunt that Clark was going to be performing at the Brotherly Slam and the match that night. Were you assisting with the stunt?
I was up on the catwalk.
And what was your role on the catwalk?
I was the one who was lowering Clark down with the ropes.
And you mentioned ropes. What kind of equipment was used for that stunt?
For that stunt, we had a vest, a rope, a carabiner, and a snap shackle.
On August 6th, was all of that equipment connected properly?
Yes, it was.
So after you made sure that it was connected properly, what happened next?
Well, that day when we were lowering him into the ring, maybe about 3 seconds in, I saw Clark do one or two quick movements, almost as if he was about to start flapping his arms. And then the thing released and he fell.
Mr. Cotter, what did you do after Clark fell?
I ran off the catwalk, ran down, called 911, and they carried him away on a stretcher.
I want to take a step back for just a moment and talk about how KWA prepares to pull off stunts like this one. Has KWA ever done anything similar?
We have. We've done one stunt similar in 2021.
And in 2021, was the wrestler in that stunt supposed to release themselves from the vest and harness they were wearing?
No, ma'am. For the stunt in 2021, that person was descended and then they would ascend back up to the catwalk. They didn't release themselves.
So just to clarify, for the stunt that Clark was going to be performing, he was supposed to release himself from the harness and vest.
Yes.
Now for the 2021 stunt, did KWA hire anyone to assist in the stunt?
We did. At that time, we had a stunt coordinator named Sarah Williams.
What was Sarah Williams' role for the stunt?
She basically planned the stunt, brought in the equipment, and was the one lowering the wrestler down on the ropes for that year.
Did KWA hire Sarah Williams back for Clark's stunt?
No, we didn't.
Well, Mr. Cotter, if you hired a stunt coordinator in 2021, why would you not hire a stunt coordinator in 2022?
For the 2022 stunt, we recycled the equipment we had used for the 2021 stunt. And when Sarah was there a couple years back, she actually showed me how to do it. So I figured I had the knowledge and I had the equipment to be able to do it.
Now, moving specifically to Clark Stunt in 2022, how do you start preparing for Clark Stunt?
Well, we ended up getting the equipment and then we had a couple of practice runs.
When did you start practices for the stunt?
A couple weeks beforehand.
I want to start talking about the very first practice that you ran for that stunt. Were there any issues with that day?
There were a couple of issues. Clark, about the second time we tried to do the stunt, he started flapping his arms up and down. Told him that was not a good thing to do, said it was dangerous and that it could be a matter of life or death.
Mr. Cotter, referring specifically to the first practices that Clark did before more equipment was brought in or changed, were there any issues with those practices?
Yes, it was when we started using the 2 carabiners, we found out the equipment set we had recycled from 2021 just wasn't working for the stunt for that time.
And what did you do to try to fix the problem that the stunt just wasn't working with that equipment?
Well, I went online, started doing a little bit of research as to what other things could be used, and I ended up coming across the snap shackle.
Did Clark end up practicing with the snap shackle?
He did.
Did anyone else use this equipment with the snap shackle besides Clark?
No, ma'am. When I was explaining it to Clark, I offered to be able to be the one to try it out first, but Clark insisted that he was the one to get it the first time.
Was Clark ever instructed on how to use the snap shackle?
Yes, when we were practicing, I told him that he couldn't move around too much because it could end up releasing the shackles.
Now, going back to something you said earlier, you said there was an issue with practice when Clark was flapping his arms. How did you address that?
Well, after that stunt had finished, I went down and met him on the mat, and I told him that that was absolutely a no-go and that it was extremely dangerous.
And after you said that to Clark, did you continue to practice with him that day?
We did. We did 2 more runs that day.
During those 2 more practices, was Clark still flapping his arms?
No, he followed the plan exactly, kept his arms still.
No further questions, Your Honor.
Thank you.
Cross-examination?
Yes.
May I proceed?
Yes.
Good afternoon, Mr. Cotter.
Good afternoon.
You'd agree that when it comes to wrestling, safety is important.
I do.
Nothing is more important than the safety of your wrestlers,
That's extremely right.
including money.
Yes, ma'am.
But in the summer of 2022, your company was struggling financially.
We were.
You were afraid you had to shut down.
Yes, ma'am.
You needed to start making more money,
That's true.
and fast.
Yes, ma'am.
It was in the summer of 2022 when you needed to start making more money fast that you told Clark Doig he would be doing this stunt.
That's right.
Let's talk about your defense that Clark Doig assumed the risk. Now, on direct examination, you showed us his contract, Exhibit 4, right?
That's correct.
And you pointed to the section that said he understands and accepts the risks associated with employment of the services.
Yes, ma'am, the assumption of risk clause.
Sir, nowhere in this contract does it say what those risks are.
No, ma'am, it only mentions the services, and we have a separate section for those services.
Doesn't say that a risk is death.
No, ma'am, it does not.
Doesn't even mention a stunt where he would rappel 78 feet in the air.
No, ma'am.
And you didn't tell him he would be doing this stunt until after he signed this contract.
That's correct.
Let's talk about your claim that Clark Doig flapped his arms during the actual stunt. Now, during the practices, you said that he flapped his arms up and down, right?
That's right, ma'am.
You said you told him not to do that.
Told him it was a matter of life and death.
For the rest of the practice sessions, he didn't do that.
No, ma'am.
He kept perfectly still.
Just like we planned.
Let's talk about your role in this. Sir, you gave Clark Doig a device that you thought could kill him if he moved at all.
I gave him something that could be dangerous if he ignored the plan and decided to do something else.
You gave him a device that you knew could kill him if he moved his arms at all.
That's right.
Let's break that down. You knew that death was a risk of this stunt.
Yes, ma'am.
You told Clark Doig that what he did with his arms was a matter of life and death.
That's true.
You believed that if that green cord moved, he could fall,
Correct.
he could die.
That's right.
You told Mr. Doig if he didn't keep still, that green cord could move.
That's what I told him.
Still means don't move at all.
That's right.
So you believed that that green cord could get pulled and he could die if he moved his arms at all.
Yes, ma'am.
Let's talk about whether that was safe. Now, you didn't buy the snap shackle from a company specializing in stunt work.
No, ma'am, I ordered it online.
You didn't order it from a company specializing in rock climbing equipment.
No, ma'am.
You bought it on Amazon,
That's right.
based on a Google search.
Yes, ma'am.
You typed into Google, what kinds of locks can I use to lower a person?
That's what I searched. Yes, ma'am.
You didn't do another Google search for what kinds of locks do stunt companies use to lower a person?
No, I didn't.
Or what kinds of locks do wrestling companies use to lower a person?
No, ma'am.
Or what kinds of locks can I use to safely lower a person?
No.
You did one search.
That's right.
That one search didn't include the word safe.
No, ma'am.
Now, Mr. Cotter, this wasn't the first time you had a wrestler rappel down from the catwalk.
It's not. We had another stunt in 2021.
And in 2021, you hired a professional stunt coordinator.
Yes, we did.
That professional stunt coordinator had you use 2 locking carabiners.
That's right.
But in 2022, you decided to replace one of those locking carabiners with a snap shackle.
That's right.
Sir, the fact is you didn't ask a single stunt coordinator whether that snap shackle was safe to use.
No, ma'am. I only saw that the snap shackle could take over 900 pounds on the website I ordered it from, and I believe that was safe. Clark wasn't 900 pounds.
Sir, you didn't call up your old stunt coordinator and ask, is a snap shackle safe?
No, I did not.
When you did this stunt with a professional stunt coordinator, no one got hurt.
That's true.
When you did this stunt without a stunt coordinator, Clark Doig died.
That's right.
A stunt coordinator would have cost you $2,000.
That's how much it would have cost. Yes.
You didn't hire a stunt coordinator because you didn't want to spend the money.
I believe that with the equipment we had and the fact that Miss Williams had taught me how to do it prior, that the $2,000 wouldn't have made a difference.
Well, now hold on. You said that you were taught how to do it earlier. To be clear, this was a different person doing the stunt,
That's correct.
a different device locked on the back of their vest,
The 2 carabiners.
and you changed that device, right, sir?
I did.
You changed it to a snap shackle.
That's right.
That snap shackle opened too early.
That's correct.
In your own words, you didn't see the point in for a professional stunt coordinator.
That's true.
Thank you, Mr. Cotter. Nothing further.
Redirect, Your Honor.
Yes.
Mr. Cotter, when you began practicing this stunt with Clark, what was the original equipment you intended to use?
Originally, we used the 2 lock-in carabiners, the rope, the vest, and that was it.
And when you made the switch to the snap shackle, how many times did Clark practice with the snap shackle?
When we changed to the snap shackle, we practiced 4 times.
And for those 4 times, did Clark ever fall?
No, ma'am.
Thank you, Mr. Cotter. No further questions, Your Honor.
Thank you.
May this witness be excused.
Yes. Certainly. Do you have any other witnesses?
Yes, Your Honor. This time the defense calls Cal Sism.
Okay.
Please introduce yourself.
My name is Cal Sism.
What do you do for a living?
I'm a safety consultant, which is what I've been doing for 23 years now, and I own my own consulting firm called Safe Performance Solutions, which I opened in 2014.
What do you do at Safe Performance Solutions?
We consult with professional wrestling companies like KWA on stunt safety.
What did you do before you opened your safety consultant business?
So I started out as a senior stunt coordinator at Warner Brothers Studios, and then after that, I became a safety consultant and senior trainer at WWE, World Wrestling Entertainment.
And are you a member of any professional associations related to your industry?
Yes, I'm a member of the American Society of Safety Professionals and the Wrestling Professionals Association.
Do you have any certifications?
Yes, I'm a certified safety professional as well.
Mr. Sism, let's move on. Let's talk a little bit about why you're here today. How did you first become involved?
I was retained by KWA to analyze these circumstances surrounding Mr. Doig's death and then provide an opinion on those circumstances.
Were you able to reach an opinion?
Yes, I was.
What kind of materials did you review in reaching that opinion?
I reviewed the plaintiff expert report as well as all the documents that were identified as exhibits in this case, and I personally inspected the KWA arena as well as all the equipment used in the stunt.
And is your opinion that you reached based on sufficient facts and data?
Yes.
And did you apply methods and principles in reaching your opinion?
Yes.
And are your opinions to a reasonable degree of professional certainty?
Absolutely.
Your Honor, at this time, the defense now offers Mr. Cal Sism as an expert in wrestling stunt safety.
No objections, Your Honor.
Okay. He's accepted.
Now, Mr. Sism, I want to take a step back real quick because we talked a lot about your consulting experience in WWE, but have you ever testified in court before?
Yes, I've testified 4 times.
Now, you said earlier you were able to reach an opinion, but first, let me ask this. Have you been in the courtroom the entire time today?
Yes, I have.
Did you hear the plaintiff's expert, Ms. Sukesh, give testimony today?
I did, yes.
Now, Ms. Sukesh says that the snap shackle used in this stunt was not safe. Do you agree with that?
No, I don't.
Why is that?
Well, the wrestling industry repurposes equipment all the time for wrestling stunts. And no offense to Ms. Sukesh, but as someone who's never worked in the wrestling industry, it makes sense why she wouldn't understand that a snap shackle could and would be used for a stunt like this one.
Okay, well, you just said that sometimes equipment is repurposed. What do you mean by that?
Well, as Ms. Sukesh said, the snap shackle is technically designed for sailboats, but repurposing equipment is common practice in the wrestling industry. Just like they do for Hollywood stunts, construction cranes to lift actors in the air, jet engines to simulate strong winds.
Okay, so based on that and what you say is common in the wrestling industry, is it your opinion that the snap shackle is appropriate for this stunt?
Yes.
And why is that?
Well, the snap shackle was appropriate because it was reasonably safe. And we know it was reasonably safe because they made sure to practice with it to make sure it was safe. And Clark had experience for stunts.
Okay, well, before we get to Clark's experience, which I'll ask you in a little bit, but first, do you understand how this equipment works in this case?
I do, yes.
And would you be able to demonstrate how this snap shackle and this locking carabiner was supposed to be used on August 6, 2022?
Yes, absolutely.
Your Honor, may Mr. Sism step down and do that demonstration for the jury?
Certainly.
Now, Mr. Sism, I'm going to hand you what's already been admitted as 6A and 8A, the snap shackle and the carabiner. Can you show the jury how these two pieces of equipment were used on August 6th?
Your Honor, may I reposition myself so that I can see the demonstration?
Yes, you may.
Thank you.
So the plan for the August 6th stunt was for the locking carabiner to be attached to the back of the snap shackle like this. And then the snap shackle will be attached to the vest that Mr. Doig was wearing.
Okay, so if the snap shackle was attached to Mr. Doig's vest, where was the carabiner attached to?
The locking carabiner was attached to the rappelling rope that was attached to the ceiling.
I'm going to take the snap shackle from you. Now, you have in your hand the carabiner. Can you explain to the jury exactly how the mechanism on the carabiner works?
Yes, so to open the locking carabiner, you have to twist the lock and then push the lock inwards. The locking carabiner can hold 6,000 pounds, so it opens when you apply pressure to it.
Okay, well, how much pressure do you have to apply to open the carabiner?
So to twist the lock, it takes 10 pounds of pressure, and then to push the lock inwards, it takes 30 pounds of pressure.
Well, I'm going to switch with you, and I'm going to give you the snap shackle now. Can you now explain how the snap shackle works?
Yes, so to open the snap shackle, it takes almost the exact amount of pressure as it would to twist that locking carabiner. So to be exact, it's 9 pounds of pressure to pull the pin and then release the lock on the hook on the snap shackle.
I'm going to take the snap shackle from you. So based on what you just showed us and what we've talked about here today, can you show us how Mr. Doig was suspended in the air on August 6th?
Yes, so the plan was for Mr. Doig to be suspended with his arms stretched out wide by the rappelling. And as he was lowered down, only when it was time for Mr. Doig to release himself, that green cord on the snap shackle would be attached to his shoulder right there. So when it was time to release, he would reach over to his shoulder, pull that cord with 9 pounds of pressure, and only then would he be released from that snap shackle.
Thank you, Mr. Sisson. Sit back down. Talked a lot about practices earlier. Do you know if Mr. Doig and KWA practiced with this equipment?
Yes, they practiced with equipment. Cody was at the practice with Clark, and Cody actually offered to perform the stunt during the practices before Clark did it, and Clark said no, that he wanted to do it. And they practiced 4 times, 8 times total.
So how many times with the snap shackle, just to be clear?
4 times.
And we've heard a lot today about a flapping motion with Mr. Doig's arms. Do you know if Mr. Doig was seen flapping his arms during the practices?
Yes, he was.
And what about during the actual performance on August 6th?
Yes, he was also seen flapping his arms by Cody Cotter.
And is that kind of motion the motion that would open that snap shackle?
Yes, it's possible that the movement up and down of the arms could open and release that snap shackle.
Okay, so knowing that, is it still your opinion that the snap shackle was safe for this stunt?
Yes, the snap shackle was the appropriate piece of equipment and was the most practical piece of equipment for this stunt.
Okay, so now I want to go back and visit what you said earlier. You said something about Mr. Doig's experience. What does Mr. Doig's experience have to do with the stunt?
Well, we know that Mr. Doig was experienced in high-flying, high-risk aerial stunts. That's what he was known for. And that was one of the main reasons why I considered this stunt to be reasonably safe, is because of his experience. And from what I can tell, the August 6th stunt was much safer than prior jumps that Mr. Doig performed where he was not harnessed at all.
Well, Mr. Sism, why do you say that the prior jumps or stunts that Mr. Doig did were safer than this one on August 6th?
Well, because of the harness equipment. I'm saying the August 6th stunt was safer because he was wearing the harness and because he was attached to a rappelling rope, which was locked up into the ceilings by the steel cables.
Okay, so if the prior stunts that Mr. Doig did were not as safe as what happened on August 6th, then what's the explanation for what happened on August 6th?
Well, the only explanation would be that Mr. Doig ignored the warnings that he was given by KWA and that he moved just enough for that pin to release, and that's what made him fall.
No further questions, Your Honor.
May I proceed?
Yes.
Good afternoon.
Good afternoon.
As an expert, you'd agree it's important to be impartial.
Yes.
It's important to approach each case with... I'll ask that again. It's important to approach each case with an open mind.
Yes.
Before today, you've testified in trial 4 times.
Yes, that's correct.
Every time for the defendant,
Yes.
every time for a professional wrestling company.
Yes, that's how it worked out.
Today, you're testifying for the defendant,
That's correct.
a professional wrestling company.
Yes.
Let's talk about whether the defendant gave Mr. Doig enough practice with the snap shackle. You'd agree. It's important for a wrestler to be familiar with their stunt equipment,
Yes.
especially if that stunt could cause them to die.
Yes.
The defendant showed Mr. Doig the snap shackle for the first time on August 6th, 2022,
That's correct.
the day of the stunt.
Yes, that was the day of the stunt.
According to Mr. Cotter, he didn't show Mr. Doig the snap shackle until 4 p.m.
Yes, I believe that was the time.
Mr. Doig went up at 8 p.m.
That's correct.
So the defendant didn't show Mr. Doig the snap shackle until 4 hours before he performed.
Yes.
Let's talk about the danger of this stunt. The stunt started at the catwalk, right?
Yes, it did.
78 feet high.
Yes.
There was only one piece of equipment directly connected to Mr. Doig's vest,
That's correct.
the snap shackle.
Yes.
If that snap shackle opened from high up, a performer could fall.
Yes.
A performer could die.
Yes.
Let's talk about whether the defendant should have switched to using the snap shackle. The defendant did a similar stunt in 2021, correct?
Correct.
A stunt coordinator provided the equipment,
Yes.
including the locking carabiner.
Correct.
The locking carabiner is the industry standard for slow-moving descents like this one.
Yes.
The locking carabiner is stronger than the snap shackle.
That's correct.
It's harder to open.
Yes.
It's safer.
It is safer, but that does not mean that the snap shackle was not safe as well.
But you believe the locking carabiner was safer, correct?
Yes, yes.
For this stunt, the defendant chose the snap shackle.
Yes.
Let's talk about why Mr. Doig died. You tested all of the equipment used in the stunt where Mr. Doig died, correct?
Yes, I did.
The vest didn't break.
No, it did not.
The ropes didn't rip.
No, they did not.
The locking carabiner didn't open.
Nope.
None of the equipment approved by a stunt coordinator failed.
Correct.
The one piece of equipment that opened was the one piece of equipment not approved by a stunt coordinator.
The snap shackle opened, yes.
When the snap shackle opened, Mr. Doig fell.
That's correct.
Mr. Doig died.
Yes.
Thank you. No further questions.
Thank you. Certainly.
Mr. Sism, you were asked on cross-examination about locking carabiner and that it is safer or stronger. But just to be clear, just because the carabiner is stronger, does it mean that the snap shackle isn't safe?
No, not at all. I think the snap shackle is reasonably safe and appropriate for this stunt.
Yes, you're excused.
Your Honor, at this time, the defense has no other witnesses, and we rest our case.
Okay.
We would like to re-raise our mid-trial motion under Rule 50 of the Federal Rules of Civil Procedure, because based on the close of the evidence today from both sides, no reasonable jury could conclude, even in a light most favorable to the non-moving party, that KWA was negligent and that negligence caused Mr. Doig's death. Furthermore, sufficient evidence has been provided or produced today that shows that Mr. Doig assumed the risk of what happened on August 6th as a professional wrestler during a professional wrestling stunt. And for those reasons, this motion is due to be granted.
Okay.
Your Honor, this motion should be denied because in the light most favorable to the non-moving party, the plaintiff, a reasonable juror could still find that we've met our burden and that the defense hasn't met theirs on the assumption of the risk defense. As for the three elements that we had to prove, their own expert testified to the defendant's negligence by confirming that the snap shackle violated industry standards. The defense didn't present any evidence that Mr. Doig didn't suffer any harm. It's still true that he died. And further, their evidence only compounded the fact that the defendant's negligence of using the snap shackle, which violated industry standards, caused Mr. Doig to fall and die. As for the assumption of the risk defense, the defense has the burden, and a reasonable juror could still find that Mr. Doig didn't understand the risk of the stunt because no eyewitness or expert was able to clarify that he actually did assume these risks or understood them. This motion should be denied and the question should go to the jury.
Okay. All right, after hearing your arguments, the motion is denied.
Yes, Your Honor. At this time, may we have another time check and a small break before closing arguments?
Certainly, we'll get the time check.
Thank you.
And you're requesting 5 minutes?
Yes, Your Honor, if that is amenable.
Absolutely, we'll take a 5-minute recess. You want everyone to have one positive thing to say each person?
No, just one positive thing overall.
Overall.
Yeah. So plaintiff will give the closing, the defense, the plaintiff gets rebuttal. They're not going to use their 20 minutes. They're going to
Okay.
use 12.
Okay.
And
And then do you want 5 minutes and then them, or you want everybody to start right away?
so once you guys, then you guys will submit
Because
your
you got to
ballots.
calculate.
I'll make sure I've got all the ballots.
And you would do it right on here?
Exactly.
Okay.
And then once I do that, we'll start the feedback and then honors the winner.
Okay. So while you're calculating, we're going to do the feedback.
Once I make sure that everyone's pressed submit.
Okay.
Yeah.
Yep. Sounds good. You're doing great.
So I'm like 4 blocks. So we're gonna give it like one and, well, this bottom one is like.
All right, I think I hear the boss coming back into the courtroom. Here he is, the boss is here. No, I said I'm waiting for the boss. So the boss is now back. So court is now back in session, and we're ready for closing arguments unless there's anything else.
We're ready to proceed.
Okay,
We're ready.
all right, we'll hear closings.
May I proceed?
Yes.
78 feet. The defendant put Clark Doig 78 feet in the air with no net. They knew whatever clip they gave him had to stay closed. If it didn't stay closed, he would fall. If it didn't stay closed, he would die. When he needed a clip that would stay closed, the defendant gave him this because of how easily it opened. The defendant is responsible for Clark Doig's death because easy to open meant easy to die. As a plaintiff, we had the burden to prove that more likely than not, Klein Wrestling was negligent, and their negligence caused Clark Doig's death. We've met our burden with 3 simple facts. The defendant had safe equipment. They replaced it with dangerous equipment. Their decision killed Clark Doig. Let's start with fact number 1. The defendant had safe equipment. As the judge will instruct you, negligence is failing to do what a reasonable person would do in the same circumstances. So how would a reasonable wrestling company perform this stunt? To answer that, we called Miss Sukesh, an expert trusted to oversee Disney stunts. She told you how to do this stunt. Use a locking carabiner. The defense said, well, you can't trust Miss Sukesh. She doesn't do wrestling. So we asked their expert, what's the industry standard? What do other wrestling companies use? Their answer? They use the locking carabiner. But if 2 expert opinions wasn't enough, we've got a third. The defendant did this stunt in 2021, hired a professional stunt coordinator. What did she tell this defendant? Use a locking carabiner. That's not a battle of the experts. That's a consensus of the experts. Members of the jury, how many experts do they need to hear from before they realize it's true? If you're going to put someone 78 feet above the ground and you don't want them to hit the ground, there's one option: locking carabiner. That brings us to fact number 2. The defendant replaced the safe equipment with the dangerous equipment. In the defendant's opening statement, they told you when you ignore the plan, you invite the risk. We agree. When the defendant ignored the plan that the stunt coordinator gave them, they invited the risk. The snap shackle. The defendant's expert told you about his decades of experience in the wrestling industry. And they couldn't give you one other wrestling company in the world that has ever trusted a man's life to this device. The defendant took a device used by everyone and replaced it with a device used by no one. That's negligent. And they could have hired a stunt coordinator, could have asked her, hey, is a snap shackle safe to use? But they didn't want to spend the money. They didn't see a point. They literally put savings over safety. That's negligent. Instead of asking a stunt coordinator, Cody Cotter asked Google, what kinds of locks can I use to lower a person? Members of the jury, could you imagine if other professionals treated safety like that? If your doctor typed into Google, what kinds of tools can I use to operate on someone? They trusted Clark Doig's life to a Google search. That's negligent. And that's how they found the snap shackle, a device that's so sensitive that if you barely move, it opens. You've heard the expression within an inch of his life? They put him within a quarter inch of his life. And as dangerous as the snap shackle was, they somehow made it worse. Because Cody Cotter told us he taped this green cord to Mr. Doig's shoulder. He said, I knew if he moved at all, he could die. Think about that. They gave him a device that they knew could kill him if he twitched, squirmed, sneezed. That's negligent. Their expert summed it up. They took a device that was stronger and safer and replaced it with one that was weaker and more dangerous. That is negligent. But the defense, they had their list of excuses. They told you, well, the snap shackle, it could hold 900 pounds. Clark Doig didn't weigh 900 pounds. That doesn't matter. It doesn't matter if it can hold 900,000 pounds. If it opens too easily, it's not safe. They told you, well, the other equipment was safe. That doesn't matter. A chain is only as strong as its weakest link. They told you, well, we practiced with the snap shackle. It was fine. They practiced with it 4 times. The 5th time, it killed him. Members of the jury, 20% is a pretty high fatality rate. And then they said, well, Mr. Cotter just thought the stunt would look so much better with the snap shackle. It releases quicker. Translation? They cared more about how Clark Doig looked than whether he lived. Remember, they weren't choosing the color of his cape or whether to use glitter. They were choosing a device that could keep him from falling to his death. Fact number 3. Their decision killed Clark Doig. We know the snap shackle was the equipment that opened. That was the break in the chain. Their expert had to admit Clark Doig fell because that snap shackle opened. Let's take a look at your verdict form. Question 1. Did we prove that Klein Wrestling was negligent and that their negligence caused Clark Doig's death? The defendant chose a clip that opened too easily. When it opened too easily, he died. You can mark yes next to question 1. Question 2. Did the defense prove that Clark Doig assumed the risk of his injuries? Now for that, the defense had the burden. But to prove that Clark Doig assumed the risk, they had to show he understood the risks, that he appreciated them, that he truly knew the dangers of this stunt. So they showed you Exhibit 4, his contract. They said, look, he signed it. Members of the jury, how could this show that he understood the risks of the stunt when it was signed a year before he was told he'd be doing the stunt? They said, well, Clark Doig, he was an experienced stuntman. He knew the risks. Not of the snap shackle. First time he saw this thing was hours before the show. Clark Doig didn't understand the risks because the defendant never told him. The defendant never told him, hey, the snap shackle, it's not approved of by a stunt coordinator. Never told him, hey, the snap shackle, it's more dangerous than the locking carabiner. Never told him, hey, if that green cord moves just a quarter inch, you're gonna die. You can mark no on question 2. Question 3. Did the defense prove that Clark Doig's own negligence caused his death? The defense said that Clark Doig flapped his arms during the stunt, and that's why he fell. But here they had the burden, and they couldn't prove that. They said, well, Mr. Doig, he was flapping his arms during practice. Okay, and then Mr. Cotter told him to stop. So he stopped. They said, well, Mr. Cotter saw him move his arms right before he fell. Members of the jury, consider the source. The only person who told you that Clark Doig did something wrong is the person whose company is on trial for wrongful death. The fact is, the defense's flapping theory doesn't make any sense. They want you to believe that Clark Doig risked his life to get a bigger reaction from the crowd. If that were true, why would he start flapping his arms before the crowd could see him? Clark Doig didn't die because of what he did. He died because of what they did. You can mark no on question 3. And if these are your answers, you're done. Members of the jury, one of the most painful parts of this tragedy is how easily it could have been avoided. The defendant didn't need to go out and buy safe equipment. They already had it. They already knew it worked. The defendant went out of their way to replace safe equipment with dangerous equipment. When they needed something that would stay closed, they looked for something that would open. Find the defendant liable for Clark Doig's death, because easy to open meant easy to die. Thank you.
A moment to prepare the will, Your Honor.
Certainly.
I'll move it. Yeah. Put it back here. May it please the court, opposing counsel, members of the jury. When you ignore the plan, you invite the risk. Some jobs are dangerous. Some jobs more dangerous than others. Whenever Jalen Hurts leads the Eagles out on the field, they know there's a chance or risk they may get hit. And whenever NASCAR drivers fly around the track, they know there's a risk that they may collide into another car. But what happens when you ignore the plan? When you ignore the plan, you invite even more risk. Because you see, professional wrestlers are no different from football players or NASCAR drivers. Now, before I go any further, let's get something very clear. Our hearts go out to Mr. Doig's family. He was a member of KWA's family. He was KWA's best wrestler. That's why his death was as much of a shock to Cody Cotter and to the folks at KWA as it was to everyone else. That does not mean that KWA was negligent. Now, the plaintiff was right. When they brought this lawsuit, they took on a burden. They had the burden to prove today by the great weight of the evidence that KWA was negligent and that negligence caused Clark Doig's death. The plaintiff failed to meet that burden today because the evidence showed three different things. It showed that KWA reasonably planned this stunt, that KWA reasonably practiced this stunt, and that despite the plan and despite the practice, Clark Doig ignored the plan and he invited the risk. So let's take those one by one and we'll start with the plan. Now, to be clear, KWA is not some pop-up wrestling company that's operating in the high school gym. KWA is a professional wrestling company who employs professional wrestlers who do professional wrestling stunts. Now, I'm the first to admit, professional wrestling is risky. Professional wrestling can be dangerous. That's why people come to the show. They come to watch the wrestlers hit each other with chairs and jump off of 12-foot ladders and jump off of 16-foot cages and go through windows. But make no mistake, the wrestlers who perform these stunts are professionals. Professionals who plan and prepare for the risk that they take. KWA is no exception. Clark Doig was no exception. Now, we heard a lot today about a stunt that happened in 2021. Sid Gaskins told you about the stunt. Cody Cotter told you about the stunt. And at that stunt in 2021, Cody Cotter did hire a stunt coordinator. The stunt coordinator brought the equipment in, helped prepare, helped practice, and Cody was there every step of the way. The only difference between what happened in 2021 and what happened in 2022 was that Cody brought the snap shackle. The only reason the snap shackle was used, as we heard today from Sism, was because it was the most practical for the stunt. The stunt needed a quick release. Clark Doig knew it was the most practical for the stunt because Clark Doig preferred it. The plaintiff knows Clark Doig preferred it. But even knowing that, they trotted out their so-called expert, Miss River Sukesh, to come in here and to tell you that the snap shackle was not safe. To come in here and to tell you that the snap shackle should not have been used. To come in here and to give all of you an opinion about an industry she's never worked in a day in her life. Until she was hired by this plaintiff for this case. But you heard from Sism. And I agree with the plaintiff. This was not a battle of the experts. Because there was only one real expert in this courtroom today. Sism is the only expert who has experience in coordinating wrestling stunts. Sism is the only expert in this case who has spent his career coordinating stunts for wrestlers. Sism is the only expert in this case who is qualified to tell all of us that the snap shackle was safe. And we know that the snap shackle was safe because we heard how they tested it and how it holds enough weight. It holds almost 1,000 pounds. Cody Cotter knew that. But despite that, plaintiff just got up here and argued that the snap shackle still wasn't safe and that they should have used a stunt coordinator in 2022. Members of the jury, as if that would have made a difference, because I don't want you to get confused. Remember, 2 different stunts, 2 different purposes. 2021, they didn't need a quick release. 2022, that's what the stunt was designed for. That's what Clark preferred. That's why they used the snap shackle. This stunt, like all stunts, was risky. Which brings me to my next point, is that just like all of the stunts that KWA has ever performed, they practiced this stunt to make sure it could be done safely. You heard about how they practiced it 4 times with Mr. Doig, with the snap shackle. They practiced it 4 times before he ever did the performance on August 6th. Now, they want you to think this was all on Cody Cotter, that this was Cody's decision to use the snap shackle. But as we heard today, remember that Cody Cotter was at every practice. Cody Cotter was manning the ropes at every practice. Cody Cotter walked up on that catwalk at every practice, and he was there at the ring at every practice to make sure that Mr. Doig got safely to the mat. Because after he left the catwalk, he would walk down to Mr. Doig and he would check on him. That was the only reason that he knew that Mr. Doig was flapping his arms during the practices. It's the only reason he knew to tell Mr. Doig to stop flapping his arms. They practice this stunt just like they do every other stunt. Cody was there, Sid Gaskins was there, and they both told you that they saw Mr. Doig flapping his arms. Now, Mrs. Sukesh, who had several opinions she did not share with you on direct examination until I asked her about them, has the opinion that KWA didn't give Clark Doig clear enough instruction. That they didn't clearly warn Mr. Doig about the dangers of the snap shackle. We know that's not true because Cody Cotter told Clark Doig, don't flap your arms like that. It's not safe. You need to be still. This is for your own safety. This is a matter of life and death. How much more clear could you be than don't do that flapping motion with your arm? How much more clear could you be than this is for your own safety, you need to be still? How much more clear could you be than this is a matter of life and death? Clark knew that the stunt was dangerous. That's why they practiced it. That's why they planned it. Which brings me to my final point. Because in a minute, the judge is going to tell you what negligence is. What she's going to tell you is that negligence does not mean that KWA had to choose the safest alternative or that we had to eliminate all risks, because it's impossible. You can't eliminate all risks. But what that means for the plaintiff is that it doesn't matter what they say about the snap shackle. We know that it worked, and we know that it was safe because we know it never accidentally released in the 4 practices. It never accidentally released or prematurely released during any of those practices. And we know that Clark saw the snap shackle that night and before practices, that he learned how to use it, that he voluntarily put it on, and that he went up to the catwalk and he used it. Their burden is negligence. Make them explain to you why this worked 4 times, but not the 5th. We know why it didn't work. Our burden to you was to prove that Clark Doig assumed the risk, that he appreciated the risk, that he voluntarily participated, and that he died because of the risks. Sid Gaskins and Cody Cotter saw Mr. Doig that night. During the practices, flap his arms. He practiced it 2 more times, perfectly still. And on the night of August 6th, Cody Cotter was manning the ropes and started to lower Clark down. And despite the warnings, despite the pleas, despite explaining what could happen, he started to watch his best technical wrestler do the thing he warned him about. It was flap his arms. And they told you to check the source. Cody Cotter can't be trusted, right? But you know what? I'll level with them. Check the source. You don't have to trust Cody Cotter. Don't take his words, take Clark's. Because what did he say right before he jumped from the catwalk? When he was asked if he wanted to go through with it. One final time, do you want to do this? He said, it's time for the dragon to fly. That was Clark saying, I got this. I know what the risks are. I know what I'm doing. Based on that, we know that Clark Doig assumed the risk. When you get your verdict form and it asks you whether or not KWA was negligent, we know that KWA was not negligent because we know that it was reasonably safe. We know that Clark Doig assumed the risk. And based on that, I ask you to find KWA not liable.
Certainly.
May I proceed?
Yes.
Defense counsel just got up here and asked you, would a stunt coordinator have made a difference? Members of the jury, we don't have to wonder. We know. When they did this stunt with a stunt coordinator, no one died. When they did it with the industry standard equipment, no one died. When they did it without a stunt coordinator, Clark Doig died. When they did it without the industry standard equipment, Clark Doig died. They told you, well, we didn't need a stunt coordinator because Cody Cotter already hired one before. He knew what to do. Here's the problem with that excuse. It only works if you do the stunt exactly how that stunt coordinator planned. But Cody Cotter had to admit, different person, different device. The device that failed. And then they admitted it. Defense counsel admitted why they switched from the safer device to the dangerous device. They said, oh, we needed a quick release, and the safer device, it was too hard to open. Really? Did that look hard? Now you might be thinking, oh, well, he had to do it behind his back. Maybe they should have had him practice with it more instead of risking his life. Find the defendant liable. Thank you.
Okay, so now that the trial has come to a conclusion, we're going to take 5 minutes for the jury to deliberate. So if anybody else in the courtroom wants to take a 5-minute break, but we're not going to get a break because we're going to deliberate, and then we'll come out and give them some brief remarks. And will you announce? Yep. Yes, and we'll announce who won the competition. Done. don't want to know what happens to your company?
Guess not.
I mean, really?
Your ballot might be tied.
Oh, no, it's not time. It's not even close to time, though.
Okay.
I don't think it's close to time. I screenshot my scores anyway, so maybe I'll try.
Or just try it again, and then if not, I'll try it from my computer.
Yeah, we can do that. Let me log out of the Wi-Fi, log in.
I'll do it.
Yeah, I guess do something. Yeah, I don't know what's going on. Now it says visitors, so let me just try.
Give your screenshot.
Yeah. I'm gonna text it to you.
You just let me look at it. Oh, just leave it right here. Thank you.
I'm sorry.
You're fine.
Am I still weird?
They might be able to hear you. I can just see.
So the, I'm not getting the score. Defense case in chief. Okay, and then I took some notes, so.
Just tell me what scores you want for your defense case in chief, and I'll do it.
Hold on. I know, I
Okay. I'm going to pass the mic to our panel of judges here and have them introduce themselves and tell you what their favorite moment from trial was. So I'm going to start with Tom. Put you on the spot.
Hi, everybody. My name's Tom Innes. I've been with the Public Defender's Office of Philadelphia my entire career. I'm also a program director for the National Institute for Trial Advocacy in Philadelphia, and I also train at the Defender's Office, and I train for the Bar Association. And you guys were terrific. It was just absolutely wonderful. My one point is that use what you have. You're in this building, you're in this courtroom. Is that 80 feet? Is that 100 feet? Whatever it is, I think it makes a huge difference if you can show them that they got him lowered from, with that piece of junk thing, right? From that high up, whether you have a courtroom that you can use that here, or you talk about 8 stories high, 7 stories high, I think that would have been very persuasive. It was great.
Hello, I'm Lonnie. I am a private criminal defense attorney. I've been that since 2005. I thought you guys were all great. It was like getting in on Apple stock early that I got to see you guys because you guys are all rock stars, I swear. There's one moment that I thought was like really high end, even for a lawyer. So I'll just point it out. What was your name? Kensington, when she was qualifying her own expert. And I know the fact pattern that the Walt Disney expert wasn't a wrestling expert. You kind of got ahead of the objection before, without even arguing it, in qualifying your own expert, like you got ahead of it. And I just thought that, like, because that was the third time I saw this fact pattern, but like that was like very sharp. And the only reason I mentioned that is that I think that everybody could kind of learn from that, even like us. I thought that was my favorite moment. Thanks.
Thanks, Lonnie. My name is Guy DeAndrea. I'm a former Philadelphia assistant district attorney. I did that for 9 years, 5.5 years in homicide. And now I'm the managing partner of my firm, and I represent children, women, and men who've been sexually assaulted in an institutional setting against those institutions all across the country. Tracy and I were actually coaches here years ago, and so we've had a lot of experience in working with you all. I will tell you that I've judged so many of these across the country, Tracy and I coaching together along with others. What I loved about, as a collective from both sides, there was practically zero objections, which in real life, if you hear me object at a trial, it's almost like it's like hearing Justice Thomas ask a question on the Supreme Court. Like, it doesn't happen, right? Because I want to be able to say, the only side that's not trying to hide the truth is me. How many times did I object? And ultimately, you're going to get an objection from the other side when I say that in a closing, and it makes the point, right? So I think you allowed the trial to be tried and heard on the, I know it's all fake, but to be heard on the facts, and I applaud you for that. Your level of civility is not unnoticed by jurors to each other, and I do think that matters significantly. So truly, spectacular job on both sides in that, and I applaud you all for that.
Hello, congratulations to all of you and to your coaches as well. My name is Tracy Palmer. I started my career with a brief stint at the District Attorney's Office. I worked at Klein Inspector with the illustrious Phil, where I was partner, and then I made a sharp left turn in my career going to divinity school to pursue a path to hospital chaplaincy, which is what I now do. You all did phenomenal, just such excellent work. I think that on both sides you had really tight themes and framings of the case that you continually brought out through your opening, through your closing, through your exams, and they were simple to understand, they were compelling and grabby, and you just did a wonderful job.
Terrible. Absolutely horrible. No, I'm just kidding. Sorry. Really, you guys were awesome. My name's Tony DiUlio. I have a firm here in Philadelphia. I've been in your seats with Drexel. I coached Drexel. Now I own a plaintiff's firm in Philadelphia, so I get it. What I will tell you, both from being in those seats and doing it in the real world, preparation makes such a difference. You guys were so tight across the board. Getting through this without an objection from either side is an impressive task, but that is because you guys were so knowledgeable of your files. Make sure you take that on in your careers, because it makes all the difference in a courtroom.
Great job, guys. My name's Antima. when I was in law school, I was actually on Temple trial team, so I know exactly how you guys feel. Right now, I'm doing cybersecurity and data breach litigation. Before that, I actually tried cases both as defense and as plaintiffs, and I started my career actually at the DA's office. My boss is here, and my first, she was my advisor, my first advisor is here too, so it's really cool. Hi, guys. Great job. What I will say is that what will set you apart coming out as young lawyers is your ability to be comfortable moving about the well. And I really saw this, and Wes, you know I talked about this, the importance of the dance in the courtroom, right? Like every movement should be intentional. And I saw you guys do that, your use of your arms, your hands, when you move from place to place. That's great. You didn't say stuck in one place, and keep that up. And also keep up knowing your objections, knowing your evidence. That made a big difference for me when I started practicing. And make sure you're always cordial. Even if you're moving from center to the side, make sure you don't block your colleague. You know, little things like that will go a long way. So good luck and great job.
Hi, my name's Scott Toomey. I've been practicing for about 32 years, and I've been trying cases for just about that long. I run the Pennsylvania office for a product liability boutique called Littleton Joyce, Ugetta and Kelly. I'm also president of the Philadelphia Association of Defense Counsel this year. I want to join everybody and say that I thought you all did a great job. I thought your command of the space was great, and it's a difficult thing to do. I also thought probably the most effective moment was the demonstration where you released the snap shackle and the backpack fell to the floor. It's tough to do a demonstration and do it right. There's a lot of things that can go wrong. So I thought you did a great job.
Hello, guys. My name is Wesley Payne. I'm a partner at a defense law firm, White & Williams. I started practice as a military prosecutor and did that for a couple of years. And for the last 35 years or so, I've been on the defense side. The thing that impressed me the most was not only your poise, but confidence, even when it wasn't the best fact for your case. And you all had that ability to keep powering through. And believe me, there are a lot of times you see people hit that point and skid left and eat tumbles. You guys did not do that. That was outstanding. Great job.
Hi, congratulations. I'm sure you're all exhausted. I'm Julie McGrain. I'm an assistant federal public defender in the District of New Jersey and a practice professor of law at Drexel Klein. I thought really, given how far we are in the competition, the fact that you were all still engaged with what your opposing parties were saying and incorporating that into your arguments, responding to that with your cross-examinations, and finally with closing, you each said things that you picked up on that opposing party had said and incorporated it well into your responses. So that ability to think on the fly, even when I know how mentally exhausted you guys are, was very impressive. Congratulations.
Great job, everyone. Clancy Boylan from Morgan & Morgan, managing partner. I also head up our national trucking program. One thing I want to say, plaintiff's rebuttal, chef's kiss.
Hi, my name's Jan McDermott. I am retired from the Philadelphia District Attorney's Office, where I worked for 33 and a half years. I echo everyone else's comments. Amazing, great job. My overall compliment would be the conversational nature that you all had during your examinations, not just with your witnesses, but even on cross-examination. You listened to the answers and you continued in a way that made it enjoyable to listen to the examinations. Really good job. And you also engaged us during your direct and cross. And that's really hard to do. That usually takes a lot of experience. Usually you're only looking at the jury during your openings and closings, and every one of you did it, and it's very effective. Great job, congratulations, and good luck.
I'm last, and you took what I was going to say. See how great minds think alike, but I think your overall courtroom demeanor, all of you on both sides, is what impressed me the most. Your conversational tone, the way you handled yourself, your respect, but most importantly is your comfort level. Like being in a courtroom in this experience where, you know, you're very high energy, but also nervous. And so your comfort level in the courtroom really, it shined through with all of you. And so that I commend you with. And I know that Philip mentioned that I had the honor of swearing him in. But what he didn't say, he was humble enough not to say, was I swore him in. I think it was the day he passed the bar or the day after he passed the bar. And the reason was because his firm that hired him wanted to use him immediately. And so that's something to aspire to. So when I say your comfort level in the courtroom, I'm assuming your 3 L's, you know, to next year be able to go right into the courtroom. So I think you're all prepared. So congratulations.
So Judge, I would like to have you back to judge every single year. If you say what you said just like that. Let's get Tom here for that next year. So this is the 7th annual Battle of the Experts, and at this point, the tournament has a little bit of history. We've had 3 winners in the last 7 years, and these are 2 of those 3 winners. The defense team is from Cumberland in Alabama, who was our inaugural champion way back in 2018, and they were the #1 seed heading into this championship trial. Our plaintiff team is from UCLA. They are the reigning Battle of the Experts champion, and they've actually won the last 4 Battle of the Experts. So they were going for the 5-peat. These teams faced in round 4. It was a very close round. It was a split decision. And this trial was also a split decision. The 2024 winner of the Battle of the Experts and still champion UCLA. It's heavy. And I want to congratulate our team in Cumberland on being our finalists. They were incredible. I think this was our best final round ever. I say that every year, and I mean it. Congratulations, guys. Thank you to our judges for coming out. Thank you to everyone who's watching, all the teams who competed this weekend, and we'll see you next year. Oh, I'm in the picture, sorry. Am I still in the picture? Sorry.